This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So one of our sister channels, run by Kurt Mueller, also known as Uncivil Law, the YouTube channel Uncivil Law, recently covered Kansas v. Glover, a U.S. Supreme Court case that was recently decided on April 6th. And it represents when police are allowed to make otherwise suspicionless stops of your motor vehicle, which used to be, or at least the question was the suspicionless stop a violation of law? Now, when I say otherwise suspicionless, what I mean is that the case, it revolves around whether the small amount of suspicion that the police had, which was based entirely on knowing someone's car. So think of like my mom in her minivan running around running her errands. If I see mom's minivan, I'm going to assume mom is driving that car. Well, what if I'm a police officer and I know who owns that car, and I'm just not sure if that's the driver or not? Can I still pull the driver over if there's some other reason to pull the driver over, like a warrant, or in this case, knowing that the owner of the car has a suspended driver's license? So this is a decision that is presented to us by Justice Clarence Thomas, and let's take a look at what Justice Thomas has to write. This case presents the question of whether a police officer violates the Fourth Amendment by initiating an investigative traffic stop after running a vehicle's license plate and learning that the registered owner has a revoked driver's license. We hold that when the officer lacks information negating an inference that the owner is the driver of the vehicle, the stop is reasonable. That is an incredible. I think that's an act. It's so incredible. It denies credibility to the person who's stating that. I really cannot believe that that's where we're at. But the Supreme Court is final. We are not final because we're infallible. We are infallible because we are final. Kansas charged respondent Charles Glover Jr. with driving as a habitual violator after a traffic stop revealed that he was driving with a revoked license. Now, one thing I do want to note before we get started here, people drive without driver's licenses a lot. In fact, I one time represented someone who was charged with their 22nd driving without a license charge. Glover filed a motion to suppress all evidence seized during the stop, claiming that the officer lacked reasonable suspicion. Neither Glover nor the police officer testified at the suppression hearing. Instead, the parties stipulated to the following facts, meaning the parties agreed. First, Deputy Mark Mirror is a certified law enforcement officer employed by Douglas County, Kansas Sheriff's Office. On April 28, 2016, Deputy Mirror was on routine patrol in Douglas County when he observed a 1995 Chevrolet 1500 pickup truck with a particular Kansas plate. We'll just call it the ATJ plate. Deputy Mirror ran the ATJ plate through the Department of Revenue's file service, and the registration came back to a 95 Chevrolet 1500 pickup truck. Kansas Department of Revenue files indicated the truck was registered to Charles Glover Jr. The files also indicated that Glover had a revoked driver's license. Deputy Mirror assumed that the registered owner of the truck was also the driver. Deputy Mirror did not observe any traffic infractions, did not attempt to identify the driver of the truck. That's going to be key. Did not attempt to identify the driver. Based solely on the information that the registered owner of the truck had a revoked driver's license, Deputy Mirror initiated a traffic stop. The driver of the truck was identified as the defendant, Charles Glover Jr. So it did end up that the officer was right, that the owner of the truck was driving the truck. But that's going to be the big question. Was the officer right to make that assumption? The district court granted Glover's motion to suppress the evidence. The Court of Appeals reversed, holding that it was reasonable for the deputy to infer that the driver was the owner of the vehicle because there were specific and articulable facts from which the officer's common sense inference gave rise to a reasonable suspicion. The Kansas Supreme Court reversed. According to the Kansas Supreme Court, Deputy Mirror did not have reasonable suspicion because his inference that Glover was behind the wheel amounted to only a hunch. that Glover was engaging in criminal activity. The court further explained that Deputy Merrer's hunch involved applying and stacking unstated assumptions that are unreasonable without further factual basis, namely, that the registered owner was likely the primary driver of the vehicle, and that the owner will likely disregard the suspension or revocation order of the driver's license and continue to drive. We granted Kansas' petition for a writ of certiorari, and now we reverse. So that means the suspicionless stop or otherwise suspicionless stop is legal under United States law. In the 50 states, I believe. I don't, this is a U.S. Supreme Court case, so that's going to get cited as precedent in all 50 states and territories. Under this court's precedent, the Fourth Amendment permits an officer to initiate a brief investigative traffic stop when he has a particularized and objective basis for suspecting the particular person stopped of criminal activity. And they're citing to Terry v. Ohio, which allows Terry stops. It will go over that in a different case. Although a mere hunch does not create reasonable suspicion, the level of suspicion the standard requires is considerably less than proof of wrongdoing by a preponderance of the evidence. Preponderance of the evidence is a 50-50 standard. You weigh both sides, and whichever one weighs more wins. It's not reasonable doubt. But we're not talking about reasonable doubt for a stop. It's reasonable suspicion for a stop. And obviously less than is necessary for probable cause. So reasonable suspicion is less than probable cause. Reasonable suspicion requires considerably less proof of wrongdoing than a preponderance of the evidence. Because it is a less demanding standard, reasonable suspicion can be established with information that is different in quantity or content than that required to establish probable cause. The standard depends on the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians or advocates, act. Courts cannot reasonably demand scientific certainty where none exists. Rather, they must permit officers to make common sense judgments and inferences about human behavior. An officer need not rule out the possibility of innocent conduct. We have previously recognized that states have a vital interest in ensuring that only those qualified to do so are permitted to operate motor vehicles, and that licensing, registration, and vehicle inspection requirements are being observed. And that's from the Delaware v. Perez case in 1979. Now, I hear a lot of arguments that driving is a right, and some states have even recognized that driving is a right, but the right is not an unfettered or unabridged right. The right butts up against the right to regulate motor vehicles, licensing, registration for safety and other purposes. And so you do have an absolute right to drive a motor vehicle as long as you meet the requirements and have done your paperwork, passed your test, and don't have a revoked license. That's how that works. Before initiating the stop, Deputy Merrer observed an individual operating the 1995 Chevrolet 1500 pickup truck with the Kansas ATJ license plate. He also knew that the registered owner of the truck had a revoked license and that the model of the truck matched the observed vehicle. From these three facts, Deputy Merrer drew the common sense inference that Glover was likely the driver of the vehicle, which provided more than reasonable suspicion to initiate stops. I just realized I'm not wearing a hat, so I just figured, why don't we, since it's a traffic case, I'll put on a traffic cone. My apologies, everyone, for my egregious oversight. The fact that the registered owner of the vehicle is not always the driver of the vehicle does not negate the reasonableness of Deputy Merrer's inference. Such is the case with all reasonable inferences. The reasonable suspicion inquiry falls considerably short of 51% accuracy, for, as we have explained, to be reasonable is not to be perfect. Glover's revoked license does not render Deputy Merrer's inference unreasonable either. Empirical studies demonstrate what common experience readily reveals. Drivers with revoked licenses frequently continue to drive and therefore pose safety risks to other motorists and pedestrians. This one study, the National Cooperative Highway Research Program Report 500, a guide for addressing collisions involving unlicensed drivers and drivers with suspended or revoked licenses, and the world's longest title, in 2003, noted that 75% of drivers with suspended or revoked licenses continue to drive. This other one said approximately 19% of fatalities in 2008 to 2012 involved drivers with invalid licenses. Although common sense suffices to justify this inference, Kansas law reinforces that it is reasonable to infer that an individual with a revoked license may continue driving. The state's license revocation scheme covers drivers who have already demonstrated a disregard for the law or are categorically unfit to drive. The Division of Vehicles shall revoke a driver's license upon certain convictions for involuntary manslaughter, vehicular homicide, battery, reckless driving, fleeing or attempting to elude a police officer, or conviction of a felony in which a motor vehicle is used. Reckless driving is defined as driving any vehicle in willful or wanton disregard for the safety of persons or property. The division also has discretion to revoke a license if a driver has been convicted with such frequency of serious offenses against traffic regulations governing the movement of vehicles as to indicate a disrespect for traffic laws and a disregard for the safety of other persons on the highways. Has been convicted of 3 or more moving traffic violations committed on separate occasions within a 12-month period, is incompetent to drive a motor vehicle, or has been convicted of a moving violation committed at a time when the person's driving privileges were restricted, suspended, or revoked. Other reasons include violating license restrictions, being under house arrest, and being a habitual violator, which Kansas defines as a resident or non-resident who has been convicted 3 or more times within the past 5 years of certain enumerated driving offenses. The concerns motivating the state's various grounds for revocation lend further credence to the inference that a registered owner with a revoked Kansas driver's license might be the one driving the vehicle. Glover and the dissent. There's a dissent here. Now, I apologize. We're not going to go over the dissent. I want to go over what is the good law, and we don't have enough real time to go over the dissent. I would like to go over every dissent and every other piece of information, but we don't. So if you want to read the dissent, I will have these documents on our Patreon, our Sponsus, and our lawfulmasses.com website. First, Glover and the dissent argue that Deputy Merrer's inference was unreasonable because it was not grounded in his law enforcement training or experience. Nothing in our Fourth Amendment precedent supports the notion that, in determining whether reasonable suspicion exists, an officer can draw inferences based on knowledge gained only through law enforcement training and experience. We have repeatedly recognized the opposite. In Navarrete, we noted a number of behaviors, including driving in the median, crossing the center line on a highway, and swerving, that, as a matter of common sense, provide sound indicia of drunken driving. In Wardlow, we made the unremarkable observation that headlong flight, wherever it occurs, is the consummate act of evasion and therefore could factor into a police officer's reasonable suspicion determination. And in Sokolow, we recognized that the defendant's method of payment for an airplane ticket contributed to the agent's reasonable suspicion that drug trafficking was occurring, because we felt confident that most business travelers purchase airlines by credit card or check rather than cash. So too here. The inference that a driver of a car is in... Wow, wait a second. So if you pay for your airline ticket in cash, the agent has reasonable suspicion of drug trafficking. I just point that out there. That's what Sokolow says, apparently. Let's go over that one, too. The inference that a driver of a car is its registered owner does not require any specialized training. Rather, it is a reasonable inference made by ordinary people on a daily basis. As I said earlier, when I see my mom's car, I assume my mom's driving it. Like, it's hard for me to go against the court's determination that that's reasonable. I'm not a police officer, and I'm not suspecting my mom of anything other than driving her car. But it feels perfectly natural when I see my mom's car, when I see my dad's Subaru. I assume that that's the person who's driving. Now, I'm not making Fourth Amendment determinations based on it, so there has to be something more here. But the dissent reads our cases differently, contending that they permit an officer to use only the common sense derived from his experiences in law enforcement. Such a standard defies the common sense understanding of common sense, i.e., information that is accessible to people generally, not just some specialized subset of society. More importantly, this standard appears nowhere in our precedent. In fact, we have stated that a reasonable suspicion is an abstract concept that cannot be reduced to a neat set of legal rules. This is precisely what the dissent's rule would do by insisting that officers must be treated as bifurcated persons, completely precluded from drawing factual inferences based on the commonly held knowledge they have acquired in their everyday lives. What I'm guessing happened here is that the officer knew Glover outside of his police officer duties, so Glover is trying to argue, well, you can't use your personal knowledge, only your law enforcement knowledge. And that doesn't seem, that doesn't seem right. The dissent's rule would also impose on police the burden of pointing to specific training materials or field experiences justifying reasonable suspicion for the myriad infractions in municipal criminal codes. Thank you, Justice Thomas, for using myriad correctly. And by removing common sense as a source of evidence, the dissent would considerably narrow the daylight between the showing required for probable cause and the less stringent showing required for reasonable suspicion. Finally, it would impermissibly tie a traffic stop's validity to the officer's length of service. Such requirements are inconsistent with our Fourth Amendment jurisprudence, and we decline to adopt them here. In reaching this conclusion, we in no way minimize the significant role that specialized training and experience routinely play in law enforcement investigations. We simply hold that such experience is not required in every instance. Glover and the dissent also contend that adopting Kansas' view would eviscerate the need for officers to base reasonable suspicion on specific and articulable facts particularized to the individual, see the Terry case, as in Terry stops, because police could instead rely exclusively on probabilities. Their argument carries little force. As an initial matter, we have previously stated that officers, like jurors, may rely on probabilities in the reasonable suspicion context. Moreover, as explained above, Deputy Mirror did not rely exclusively on probabilities. He knew that the license plate was linked to a truck matching the observed vehicle, and that the registered owner of the vehicle had a revoked license. Based on these minimal facts, he used common sense to form a reasonable suspicion that a specific individual was potentially engaged in specific criminal activity, driving with a revoked license. Traffic stops of this nature do not delegate to officers broad and unlimited discretion to stop drivers at random, nor do they allow officers to stop drivers whose conduct is no different from any other drivers. Accordingly, combining database information and common sense judgments in this context is fully consonant with the court's Fourth Amendment precedents. This court's precedents have repeatedly affirmed that the ultimate touchstone of the Fourth Amendment is reasonableness. Under the totality of the circumstances of this case, Deputy Mirror drew an entirely reasonable inference that Glover was driving while his license was revoked. We emphasize the narrow scope of our holding. Like all seizures, the officer's action must be justified at its inception. The standard takes into account the totality of the circumstances, the whole picture. As a result, the presence of additional facts might dispel reasonable suspicion. For example, if an officer knows that the registered owner of the vehicle is in his mid-60s but observes that the driver is in her mid-20s, then the totality of the circumstances would not raise a suspicion that a particular individual being stopped is engaged in wrongdoing. Deputy Mirror possessed no exculpatory information, let alone sufficient information to rebut the reasonable inference that Glover was driving his own truck, and thus the stop was justified. For the foregoing reasons, we reverse the judgment of the Kansas Supreme Court, and we remand the case for further proceedings not inconsistent with this opinion. So, let me give you my take on that. So the officer saw a truck that they believed belonged to a person who had a revoked driver's license. They verified the owner of the vehicle through the license plate registration. They pulled the person over and then verified that the driver is in fact that owner with a revoked driver's license. The driver otherwise did nothing wrong and did not swerve or cross the center line or get in a car accident or collision or something. And so I think what this actually means in the larger picture is that officers can stop you whenever they have that reasonable suspicion, and until they realize that the owner is not the driver of the vehicle, they can continue with the stop. So imagine now that Mr. Glover's car gets pulled over and the officer walks up to the window and, license and registration, please, and then sees a young lady driving the truck instead. Well, now the officer knows it's not Mr. Glover. Now I think the officer doesn't have reasonable suspicion anymore and can't continue with the stop and has to say something like, "Oh, sorry, ma'am, we thought someone else was driving. Have a nice day." I don't even think they get to ask for license and registration at that point because the stop was completely unwarranted, as in no reasonable suspicion. But what I do think this enables, and this will be the title of the video, is I think this enables license plate reader stops now. Now, there probably was already some recognition for license plate reader stops, but if you're not familiar, if you look at your local municipalities' parking vehicles and police vehicles, some of them will have license plate readers bolted to the top of them. They're usually a little box. It's usually very, very, very rectangular. Sometimes if you look at night, they're flashing. They point 45 degrees or so off the driver's side roof left and the passenger side roof right. And as the police car or the traffic car or the parking car drives down the road, it takes pictures at high speed, and those pictures are analyzed in real time via hardware in the car, because there'd just be too much data otherwise, right? Has to be via hardware in the car. And they look for license plates. And if it sees a string of digits that it thinks is a license plate, it automatically gets sent out to whatever database for verification. And if there's a car that has no registration or the owner has a warrant or something, it pops up on the screen of the police officer or pops up on the screen of the dispatcher. Somebody gets it to then decide what to do with that information. Now, what I think Kansas v. Glover does is enables those license plate reader situations to then be converted into stops, even if, and especially if, you don't know who the driver is. You can automatically pull over the car if it comes back that the license plate and therefore the car is owned by someone who has a warrant, someone who has a revoked driver's license, someone who has a bad registration or car out of inspection or something. I bet you police officers can now pull that car over without having to verify anything until they get to the window and see who the driver is. And if it's the owner who the police officer thought it would have been, or the license plate reader thought it would have been, then they can continue with the stop. If it turns out to be somebody else and the violation is related to the person and not the vehicle, then they have to let them go. So what do you think of that? I think that's both scary, but it also makes sense. I really can't get my brain around the fact that when I see somebody's car, I think they're driving. My buddy John, for example, drives an electric car, and he used to drive a really unique electric car. He used to drive an electric smart car. You know those little smart cars with the tritium shell or whatever, and they're tiny and they look like a roller skate, and you can fit two of them in one parking spot. He used to drive an electric version of those right when electric cars were just getting popular, like back in 2010, 2012, something like that. And it's a cool little car, and it looks unique because it had like markings on it to tell you that it's this electric smart car and everything. Whenever I saw that car, I assumed he was driving. Maybe at best it might have been his wife driving, but I assumed that it was him driving until I knew better. And it's hard for me to think, well, an officer can't do that. An officer's not allowed to pull somebody over because they're pretty sure that the driver is the owner, or the owner is the driver.
So I had two comments. One is that I wanted to see if the statistics backed up the idea that a lot of cars only had one driver. And I wasn't able to find any statistics that say what the median number of drivers per vehicle is. But in general, in the US, you have an absurd number of cars per household. Yes. That households with one person still have an average of like 1.2 cars or 1.02 cars. And I'm like, wait a second, that means there's a whole bunch of one-person households that have two cars, because you are going to have some one-person households that don't have any cars. And I'm like, wow, that's a lot. If you have a really big family, then, so if you have a household of 7 or more, you still have an average of 3 cars. So the number of cars per driver, or the number of drivers per car, is still very close to 1. So the statistics kind of back up the idea that if the car is registered to a person, that's most likely the driver.
Yeah.
The second thing, though, is that you said if you suspect the driver of driving without a license, you pull them over, you walk up to the car and you see, oh, that's a woman in the wrong age group. That's not the person I'm looking for.
Yeah.
Then they would have to stop. But what if
they would have to stop the stop?
Yeah, stop the stop.
They would have to end the traffic stop.
But that's for a suspended license.
Yeah.
What if they are looking for a person because that person has a warrant out for their arrest? You can tell that the person driving the car is not the person you're looking for, but would you then be able to ask that person, have you seen this person that has a warrant for their arrest?
I bet you could ask, but you might have to make it clear, or at least not go farther than a question. So in other words, a lot of officers will get past Fourth Amendment restrictions by politely asking, ma'am, is it okay if we search your car? Ma'am, do you know where your husband is? Ma'am, where's your brother? There's a warrant out for his arrest. Do you know where he is? Can you help us find him? I think those are perfectly reasonable things to ask. And if the driver of the car says, sorry, officer, I'm not answering questions. Am I being charged with a crime or am I free to go? He probably has to let you go at that point.
But you also have to be knowledgeable enough to know that you aren't being forced to answer those questions.
Yeah, yes. It's almost as if an educated populace is something that our forefathers desired and wished for and tried to codify into the U.S., the formation of the country. Educated electorate, I believe. But that's why we're here, to educate you so that you know what your rights are, so that when you get pulled over, you can hopefully avoid a situation. And not every jurisdiction agrees that the smell coming from the car necessarily creates a reasonable suspicion either, but some do. So that's our show, everyone. I'm Leonard French, your favorite copyright attorney. Thank you for watching this production of Lawful Masses, your favorite legal news and education channel. Please subscribe to our YouTube channel. Please support us on patreon.com/ljfrench and sponsors.com/law. This channel would not exist without your support. We also have YouTube memberships available and Floatplane memberships available, and we're going to be doing more and more exclusive content for our supporters as I get better and better at it. Please send us your suggestions for what you'd like to see as exclusive content, and we'll figure out what to do for you as well. Thank you to our $50 plus supporters in the month of April. Thank you to Wes Delj, Video Quarantined, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Michael Pearce, Jan Negrey, Daniel Perez, Aspernari, Joe Tyson, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Nicely Done Defense, Mullen PC, Sean McNamara, Josh Baker, Ugly Grill, Gregory, Shielo T, Michael Moore, and Beastman. I appreciate you all. All the $5 plus supporters are scrolling on the LED panel over here. You'll all appear in the description of the videos that drop. I'm Leonard French, your favorite copyright attorney. Have a good week. Have a good, hopefully, final weeks of shelter in place and quarantine and all that. And I'll try to keep you up in the legal news and education with our channel here. I'll see you in the next one. Love you all. Bye.